principal character of the soldier. But even in this difficult case before a military court, obedience is not to be interpreted as blind obedience to any order, but only to legal orders, and not to orders demanding the soldier to commit crimes. Such a general criminal order given by a superior to execute a crime, the perpetrator will be responsible to the same extent as the one who gave the order. This modern approach does not put the question of a new kind of collective responsibility to the blame and fault of another, and this is not the objective approach to criminal personal responsibility. But this is a question of considering a fact which is not disputed, that a great number of crimes are committed by groups and various ranks of responsibility. This is the second reason, Your Honors, why the contention and order from above will not stand the accused. There is also a third reason. We have seen that he even overstepped his authority beyond and above the orders given to him. He was the spirit, the live spirit in all these actions. He was the man to motivate and to set all this apparatus moving. He pulled the threads. This was not a man who obeyed orders. This was not a man who did only what was demanded of him. He fulfilled the order to the very last and final bitter end. You have hundreds of documents describing any effort of saving a soul, of any intervention, putting them all to nil. The only case where he responded, can you point at it? That he ever tried to mitigate the suffering?
This was the living spirit of extermination, who lent force and vigor to this ghoulish operation. I said he didn't give the supreme orders. He was not the first who gave the orders. But when matters reached implementation stage, there he was undisputed master, and this is where he held sway over all fields of implementation, and he would press and expedite matters, and he did it with enthusiasm and zeal within the framework of orders, and to the highest extent practical, even beyond the framework of those orders. Now we will see how things can be viewed in this trial. The orders to exterminate Jews had never been attired in any form of law. Not that a law like this would have changed anything in this matter. But what was the formal basis for this tremendous operation of instructions, directives, steps, measures which transpire from the ocean of documents? Eichmann told Wisliceni, according to the latter statement, that he has Himmler's written order, saying that the Führer had decided on the extermination of Jews. Eichmann, of course, denied it most energetically. On his part, he was not trying even to testify to any written document whatsoever. But even as we assume in his favor that Viziceni's statement was correct, then even at that time we have no proof testifying to any legal basis whatsoever. And even if Eichmann had claimed that a German soldier had a duty to obey orders, then even if we take this statement as true, there was no such legal framework, there was no relevant law. And on the other hand, we have a factor which had testified to the act as crime, the very essence of murder, the very essence of herding people and like cattle, the very essence of search warrants, of tracking people like haunted bees, and all the time amid camouflage and effacing of the traces of murder. The very fact of camouflage shows us quite clearly that what was being done was illegal. What was being done was a hideous crime. If they were not aware of the fact that this was criminal, why then all this camouflage? Why this camouflage? Because the most heinous crimes had even to be concealed from the Reich's authorities. This is what he admits, not because they were better than he was, not because they were no partners, but even to them he didn't have the courage to disclose the whole truth. He was dealing with the work that anybody who engaged in it knew that this was downright crime, whichever way we are going to examine it, whatever principle is to be considered. The accused and his accomplices in this tremendous conspiracy would not boggle at acts which are considered crimes in accordance with military laws. It is enough, for instance, to point to the murder of Jewish prisoners of war, as we heard from witnesses Levinson and Buchmann. The orders came from Berlin to kill everyone. This is what the witnesses said. But some of them were left alive as forced labor.
The central nerve center of the Gestapo, it has ramifications upwards to Heydrich and to Himmler, and downwards down to the last man. However, on condition that this person had full knowledge of what was taking place, and on condition that this person remained in the criminal framework and in this nerve center after he had learned what the purpose was. And we heard this from Eichmann himself in August or September 1941. He says, Heydrich informed me the Führer has ordered the physical extermination of the Jews. And from that moment onward, he was caught in the net of the criminal conspiracy toward Heydrich, toward his subordinates, and towards all the others who were dealing in the thousands of little conspiracies which existed in every ghetto, in every community, in every country, big and small, for the implementation of the overall task. And finally, one more argument which may crop up, and this is the claim of the act of state. the doctrine of the act of state has its source in a theory from public international law, which was crystallized in various legal systems. President of Court, pardon me, sir. Will you speak some more about the opportunities for leaving the framework of the Gestapo? Mr. Hausner, yes. This will come when I analyze the paragraphs one by one. And there is a paragraph, a count in the indictment which accuses him of membership in the Gestapo. And when I come to that, I shall of course discuss this problem. The theory, as I said, of the act of state says that international public law deals in relations between states. Therefore, if an individual acting on behalf of one state commits an act which damages another state, then the state which was damaged may ask that the other state give satisfaction and compensation, whereas the individual who was only a tool, an organ of the state which did the damage, will not suffer the consequences. But even according to the people who advocate this doctrine, it does not apply to acts committed by an individual on behalf of the state when the order exceeds the boundaries of the law and exceeds the jurisdiction and competence of the state. Acts of state in wartime, which constitute a violation of international public law, are considered as exceeding the competence of the damaging state, and therefore the offenders will carry their criminal responsibility personally. For that reason, this defense was rejected in the major war criminals trial and in other trials of war criminals. And this is what was said in the judgment in the Justice's case, which the court can find on page 41 of our pamphlet. Because of the late hour, I shall not quote, and I shall content myself with the reference. Flick's case, which is also mentioned on page 41 of our material, there we read in the original that the individual criminal responsibility for international crimes is no innovation. Therefore, the accused cannot argue that he is not liable to penalty because his acts were acts of state. And the fact that this defense was not explicitly rejected in the law for the punishment of the Nazis and their collaborators makes no difference. First, our law does not mention such a defense at all. Among the paragraphs of defense and justification which are mentioned in the criminal law and which constitute in this matter the overall arrangement for exemption from criminal responsibility, and therefore obviously, there was no need to mention this in the law for the punishment of the Nazis and their collaborators, because this is a defense which does not exist in our regular criminal law. Secondly, common law as well, which can in certain cases be used in supplementation for our written law, that too does not recognize this line of defense in criminal law. American law too does not accept that defense in a way which would revoke criminal responsibility from people who acted on behalf of a foreign state. This we learn from the judgment of the United States Supreme Court, quoted in the judgment of the International Military Tribunal at Nuremberg. It is ex parte quirin, It is also quoted on page 41 of our material. President of Court, it is not in the International Military Tribunal, but it is one of the additional cases, isn't it, as you said, sir, the Justice's case. Mr. Hausner, the Justice's case quotes the IMT, which in turn quotes the ex parte querying. And with this I have concluded my pleading on the argument of act of state. President of the Court, our next session tomorrow morning at 8:30.